The following news flash is brought to you by the Lone Star Lowdown, providing your daily bulletins for the commodities market. Today in history, news updates, and the inside scoop into the tides of the alternative. Markets for Friday, February 19th, 2016 are currently trading with gold at $1,225.73 an ounce, silver $15.33 an ounce, Texas crude $30.77 a barrel, and Bitcoin is currently sitting at about 418 U.S. currency. Today in history, the year 1942. Through Executive Order 9066, President Franklin D. Roosevelt authorized the deportation and incarceration of nearly 130 mainland Japanese Americans who were forcibly relocated from their West Coast homes. The presidential order allowed regional military commanders the power to declare that all people of Japanese ancestry were excluded from the entire West Coast, except, of course, for those within government camps. American concentration camps. Today in history. In recent news, U.S. Attorney Ellen Decker wrote in a court filing today in Riverside, California, that Apple, quote, has the technical ability to comply with the court order and is refusing to assist because of concerns to its business model and public brand marketing strategy. This after Apple CEO Tim Cook a few days ago released a public statement to his customers and investors stating that, quote, the United States government has demanded that Apple take an unprecedented step which threatens the security of our customers. We oppose this order, which has implications far beyond the legal case at hand. This bold statement came in defiance to a court order by California Judge Sherry Pine for Apple to develop a new version of the iPhone's operating system, which would allow the FBI to use its computers to guess the passcode quickly without getting locked out for making too many guesses. Apple has until February 26 to respond to the court order. The United States government has issued a license to Boeing today for them to be able to conduct negotiations with airlines in Iran. However, further approvals would be needed in addition in order to make sales. Analysts are noting that Boeing faces numerous challenges in Iran. The country may not be able to afford many of their planes, and financial backers may consider investing in leases or sales to be too risky due to the possibility of repossessing aircraft in a bankruptcy. Iran continues to fly much older Boeing planes, including 11 747s that date from 1969 to 1988, according to Flight Global. Separately, General Electric, which makes engines for Boeing planes, stated that it's also applied for a U.S. license to sell engines and parts in Iran, though it hasn't been granted yet. This has been your lowdown for February 19th, 2016.
You gonna do? Yeah. Bad boys, what you gonna do? What you gonna do when they come for you? Bad boys, what you gonna do?
Okay, howdy. This is Randy Kelton, Root of Law Radio, on this Friday, the 19th day of February, 2016. And I was going to start off today with something I'm working on. I've been working on an ebook, and I've been talking about parts of it online. Today I'm going to talk about how to write legal documents. I'm doing a whole section on that. I'm going to talk about the aspect of writing a legal document from the perspective of flow. I've touched on flow before, but not in depth. So today I'm going to talk about the concept of flow. Human beings, we have the ability to look at lines on paper. And from those lines and spaces, we create meanings and understandings. We have realizations and epiphanies. In order to do this effectively, we need our capacity finally focused on the process. I'm trying to read this in what I've got written, and it doesn't read so well. Flow. Everyone's had the experience of reading a book that was so interesting and captivating that we seem to just fall into the subject matter. We can sit for a couple hours and read, and then all of a sudden it's like we come to and reorient ourselves to the world around us. Reading may well be the most hypnotic thing that I ever do, because when reading very well-constructed prose, I often focus on the content to such a degree that I lose track of everything around me. I'm sure we've all had that experience. Writers who can create that kind of experience for a reader, do not do so by accident. Being able to construct prose that engages the reader to the point that they lose track of everything else is a skill. It's not a talent. It's learning to manipulate a number of different tools and techniques. And the first thing you have to do in order to engage a reader is you have to develop rapport. And most people have heard the term rapport, but here we're going to speak to it in a finely focused perspective. Rapport in this case is not just getting someone to like you or agree with you and be essentially in step with you. Rapport is building a set of expectations and trust in the reader that the writer will fulfill those expectations. Now, if this doesn't sound like it makes sense, maybe I'll work on that. When someone reads any particular piece of writing, they come to the writing from the perspective of a subject matter. When I read a novel, I expect something different than when I read a book on science or a textbook. Each one of these I'll come to from a different perspective. And in coming to it from that perspective, I will have certain expectations of what I'm going to find here. In this case, we're addressing legal writing. So when someone comes to a legal document, they have certain expectations of style, content, and presentation. In order to get and maintain rapport, you have to make sure that you fulfill the reader's expectation in certain areas, primarily style and presentation. And from a legal perspective, that's not too hard to do because we have a specific thing we're trying to do with the legal document. And over time, legal document style has been well developed. So we all pretty much know what a legal document should look like. But we're going to get into that in somewhat more specific detail from the perspective of referential index. Now, referential index is not a term that I made up, but it's also not a common term. And it goes to the way the mind does what it does, the way the mind remembers, gathers and accumulates information, and the way it retrieves information. Referential index are the markers that the mind uses to establish context for any particular piece of information. If you give someone a piece of information and you don't give them referential index, they're likely not to remember it. If you don't tell them why that piece of information matters and in what context this particular piece of information has relevance, then they won't remember it because they won't know where to put it. In order for them to be able to save information, they have to have a frame of reference to save it from. I won't get into the cognitive model. I have a model of the living mind where I define how all of this works. Just briefly to say that this aspect of mind, referential index, is not a conscious aspect. It's something we do in a secondary level of awareness. The conscious mind pays attention to the details. You have another aspect that pays attention to context, pays attention to the underlying structure of the information you're receiving, so that it has a way of laying down information in an orderly manner where it can go back and re-access that information. If you don't give someone referential index, you will lose them. When we talk about flow, someone who is able to produce prose that a reader can read and fall into and go into what we call a state of flow, that writer has been careful never to give information without referential index. your reader always knows what the context of the information they're receiving is. When you use words, the words must have a meaning to the reader that fits in the context of the information around it. If you give someone a string of information and then drop something in there that doesn't seem to fit, the reader's going to be stopped. He's going to drop out of flow. He's going to look for referential index. He's going to look inside and say, okay, where does this piece of information go? And if he doesn't know, if you haven't given him a pointer, then he drops out of flow and has to try to figure out where to put this. In order to write a document that someone can understand and come away from with a meaning from a bunch of squiggly lines on a piece of paper, we have to pay real close attention to referential index. And the rest of this presentation will essentially be about how to some practices that will help you maintain referential index. First one is the order of arguments. In any kind of document, any kind of reading material, order of arguments, everything essentially has arguments. And I'm not speaking to arguments here in terms of father and daughter arguing or husband and wife arguing. I'm talking about a piece of information and how that information relates to what's around it. I make a statement, a fact, and then I state why that's important. I produce a legal document. There are certain things I'm going to try to do, and each of the things I'm going to try to do need to fall in a certain place. They need to land in a way that the reader will almost intuitively understand what their purpose is and how they fit together in the overall scheme of things. So in that context, when creating a legal document, you should always start at the bottom, start at the end, create the order first. The very last thing in a legal document is an order. You're going to ask the judge to issue an order that grants you what you want. So if you're going to write a cogent and well-structured document, the first thing you have to do is decide and determine specifically what do you want. At the end of the day, you're going to ask for something. You're going to ask for an order, either from the judge or from a jury. First thing you need to know is what you're going to ask for at the end of the day. You write down the order. In order to produce an order, you need to go find a pattern jury charge. Pattern jury charges are set ways of presenting information to or instructions to a jury as to what they must do to find for a given argument. And it's defined for every criminal statute, cause of action, or tort. So in the order, you will ask the court to rule in your favor based on certain elements of either criminal statutes, causes of action, or torts. Each one of those has a set of legal elements, and you're going to ask the court to rule that it found, say if you're the plaintiff, if it found this element, it found this element, it found this element. Therefore, it finds in favor of you on this cause of action or this tort. Each one of those has a very specifically defined set of elements, and you should get the charge to the jury because this will all go to flow.
You are listening to the Logos Radio Network. LogosRadioNetwork.com.
Okay, we are back. Randy Kelton, Real Law Radio, on this Friday, the 19th day of February 2015. When you write a legal document, first thing to do is write up the order that you want the judge to sign. Once you have that order structured in the verbiage of the pattern jury charges for your state, and you get a pattern jury charge for each cause of action where you have more than one cause of action or where you have more than one type. For each type of cause of action, there will be a jury charge. So you get the jury charge for each of those. You look at your cause of action and you ask the judge to rule on each element. Now, once you have that done, take that, drop it in a separate document, and put it up in the upper left-hand corner of your screen and leave it there. Then go ahead with your document. You leave it up there so it's always in your peripheral vision, because this is going to be the key focus around which everything else is structured. By keeping that order in your field of vision all of the time, it'll help to remind you that anything you put in this document, any fact, any law, any argument, must lead toward one of the elements of one of the causes of actions in that order. If it doesn't, take it out of your document. This will help to keep you from drifting off into arguments that may be very compelling and may be very interesting, but they're not relevant to the current circumstance. And they'll wind up either the court will listen patiently while you go to all the trouble of going all through these arguments, and then they'll completely ignore them, or they'll get objections for relevance. But for our purpose, we're writing a document for the purpose of flow. And we want to keep our reader in the flow all of the time. And creating the order first gives us a set of directions of how to build the rest of the document. Once we've built the order, then we build a prayer. And I talked to Jeff Cedric today, and he chastised me about using that old archaic term. He says that prayer is not specifically used so much anymore, that they've gone to other methods like wherefore. Well, that may be, and I've seen documents where the lawyer does an argument where he says that the plaintiff will prove this, will prove this, will prove this, will prove this. And then when he gets to the end of the document, he'll say, wherefore, he requests the court does this, wherefore he requests he does that. Well, that may be a method that's used. It's just not a very good one, because it doesn't clearly demarcate one part of the document from the other. Now, whether you use the term prayer or not, you need something to separate the portions of the document. When we get to the section on style, we'll talk about headings. Headings are really important. And just so this makes sense at this point, one of the things I do when I evaluate somebody's document, the first thing I do is go down the document and put a heading on every paragraph. If you're going to keep your document cogent and well-structured, you need a heading on every paragraph. You need something to tell you exactly what this paragraph is for, and keep everything in the paragraph true to the heading. Well, that's out of place, so we'll get back to that a little bit later. But for now, we want I'm going to call it a prayer. We want a section where we ask the court to do what we want the court to do. And the prayer should essentially look almost exactly like the order, except in the order, you write it in from the perspective of the judge. This is where the judge is saying he orders this, he orders that. And judges don't want to write up their own orders. They want you to do it for them so they don't have to do any work. In the prayer, it should look just like the order, except it should tell the judge, I want you to rule for me on this element, on this element, on this element, and on this cause of action. So you create a prayer just from a somewhat different voice, the voice where you're asking for the ruling, and then in the order is the document where the judge can grant you the ruling. These both look pretty much the same, except for voice. And from the prayer, you go to a statement of facts. Okay, let me back up just a little bit, just so Jeff doesn't beat me up. There are certain things that are required in a document. And I'll get to those, but I'm not following them in order for this to better understand what I'm doing here. Normally in a document, you start with the heading of the document, what the document's about. Then you put in a brief statement of what it is you're going to attempt to prove, or what you're going to ask the court for. So this gives the reader referential index. It gives the reader a context from which the reader should consider all of the information that follows. Then you would go to a section naming who the litigants are, then jurisdiction and venue, showing how the court has jurisdiction and venue to hear this particular argument. Then you'd go to a statement of facts, arguments in support, conclusion, prayer, order. We're not going to go in that order. We're going to start with the order first. We're going to go to the prayer second. Now we have direction, and that's for our benefit. Now we know what it is we're going to try to end up with. So next we go to a statement of facts. The first thing we do in creating a statement of facts is we create a timeline. If I ask someone to create a statement of facts, especially someone who's not a trained and accomplished lawyer, it has to be trained and accomplished, because if I ask a young lawyer to give me a statement of facts, I'll get facts intermingled with opinions and arguments. So ask for a timeline first. This happened, this happened, this happened. Just the date and what happened. Very briefly, just enough to tell me what happened. Don't tell me why. Don't tell me the significance of it. Just put down what happened and make a list of that. This is a mnemonic device. It's a memory device. People who have been through situations that wind up before a court generally have invested a bit of emotional trauma into the content. So when I ask someone to give me, to tell me what happened, in order for them to be able to tell me what happened, they have to go in and reaccess a memory. And to reaccess a memory, they must reaccess or revivify the context in which the memory occurred. And if it was traumatic, they have to re-experience all that trauma. Anybody out there who's ever been in a case that was of great personal importance to themselves, when they're asked to relate the facts of the case, it is very difficult. Because in order to do that, you have to go re-experience all this trauma. And while it's difficult, it's hard to get people to actually do this because it is so difficult. It's also hard for the individual to give you a true and accurate set of facts. There's a more serious issue about how this perverts memory, but I'll get to that in another presentation. Each time you have a memory, you tend to forget the original memory and replace it with the new memory you just had. If you're accessing things that happen from an emotional perspective, every time you access them, the memory you hold will be adjusted somewhat, and that can be a very serious problem. So first thing we do is ask for a timeline. Timeline is a different context. You're not asking them to re-experience what happened. Don't tell me all the stuff that happened. Just give me time frames. Now I've got the timeline laid out, and I can look at that timeline and select one little section of this whole traumatic event.
Freedom-loving Americans are finding creative ways to fight invasive airport body scanners, and they're also educating the TSA about unreasonable search and seizure. I'm Dr. Catherine Albrecht. I'll be back in a moment with the latest on scanner skivvies and Fourth Amendment apparel.
Privacy is under attack. When you give up data about yourself, you'll never get it back again. And once your privacy is gone, you'll find your freedoms will start to vanish too. So protect your rights, say no to surveillance, and keep your information to yourself. Privacy, it's worth hanging on to. This public service announcement is brought to you by StartPage.com, the private search engine alternative to Google, Yahoo, and Bing. Start over with StartPage.
Airport body scanners let TSA officials peep at your privates, and Americans are fed up with it. A Kentucky man is fighting back with privacy-friendly underwear for men, women, and children. The patriotic-themed skivvies sport metallic ink shields in strategic places to blur images of sensitive areas. Other freedom-loving entrepreneurs are selling shirts with the Fourth Amendment printed in metallic ink. The resulting body scan image is emblazoned with a reminder about constitutional protections against unreasonable search and seizure. While these are valiant efforts, the best defense is to refuse to be scanned at all. Join me in saying no to airport nakedizing machines. I'm Dr. Catherine Albrecht. More news and information at CatherineAlbrecht.com.
You're listening to the Logos Radio Network at LogosRadioNetwork.com.
Yeah, I got a warrant, and I'm going to serve them to the head government, them, prosecute them. Okay,
Okay, we are back. Randy Kelton, Rule of Law Radio, and we're talking about flow. When I fell off the cliff there, we were talking about creating a timeline. A timeline as a memory device. We won't actually include the timeline in our final document, but the timeline is for the purpose of helping us organize the facts in a way that won't contaminate the content. If you ask someone to relive the event by giving you a statement of facts, it has a tendency to contaminate the content. Timeline doesn't do that so much. It doesn't re-access the trauma. So once we get a timeline now, then we can set it aside a day or so and then go back and look at it again. And as we look at each date, new pieces of information will pop into the mind that you can stick into the empty places. And once you've done this a time or two, you'll have a pretty complete timeline. Now, once you have the timeline completed, now we get to probably the most important part about facts, is you write a story. Take this list of facts or list of times things happened, and you take the first two dates and say, on this date, this happened, and tell the things that occurred from the context of leading to the next point on your timeline, so that you you state what occurred in terms of facts this time. But now we're not looking at the whole situation. We're just looking at one portion of it. And we tell the facts in a way so that they lead from this point on the timeline to the next point on the timeline. And you go through all of the points on the timeline, telling the things that happen in a story format. Now, when you state a fact, and for the purpose of this will be attached to the document as an affidavit of fact. So when you write this, avoid getting into arguments or expressing opinions. And the way you can avoid that is at the end of each sentence, add, in my opinion. If the sentence reads grammatically accurate, if it makes sense, it's written that way, most likely it's not a fact at all, but it's a opinion or legal conclusion. Go back and look at it and make sure it only states a fact and does not argue an issue. So once you have a story that ties all the facts together, now you have a primary, very powerful tool. One of the main things we must do in developing a legal document or developing a case is we must get the facts before the court. If you put the facts in a affidavit form, and by turning it into a story, an ordinary person of reasonable prudence can read this document and make sense of it. This will cause you to automatically supply foundation. We've all heard watched programs where these lawyers are up there examining a witness and one objects, objection, foundation. You can't just put information before the court. Before you put information before the court and onto the record, you must have testimony to show why that information is relevant. So when you write a statement of facts in a story format, you will necessarily do those things to give the reader referential index, to give the reader an understanding of why this fact fits where it does. Once you have that, now you take your statement of facts, take your affidavit, and extract from it a pure statement of facts. Fact 1, this happened. Fact 2, this happened. Put each one on its separate line. One sentence, one line. One object, or one subject, one verb. Create a list of facts. This will go into the document itself as a statement of facts. Now look closely at this statement of facts. And writing the story should help get these in an order. The statement of facts must include all of the facts you need to prove up each of the elements of each cause of action. Sometimes when you write a statement of facts, in order for the statement of facts itself to make sense to a reader and to help a reader with flow, the reader needs to understand how one fact relates to another. So by structuring this, the statement of facts, so that it addresses facts that goes to each of your causes of action, you should write your story while paying attention to your order. These are the issues in the order you're going to try to prove. You put the issues in the order that they will come in your argument. You state the facts in the order they will come in your argument, so that the reader from the beginning finds what he expects to find. We're going to write the heading to the whole document last. We're going to write the introduction to the heading next to last. And the reason for that is once we have the whole argument in place, we write the introduction so it tells the reader, we're going to go from this point to this point to this point to this point to this point. And that sets up an expectation. And then when the reader looks at your statement of facts, the statement of facts follows right down that introduction. You address the issues you told the reader you would address in the order you told them you would address them. So in our statement of facts, it's important we pay close attention to that order or the prayer so that we follow all of the issues that are in the order of prayer in the order they come. Okay. Once we have our statement of facts together, and the statement of facts, writing a statement of facts is an art. As you write the statement of facts, you may go back to your affidavit and make some adjustments, because you want to make sure that when the reader reads a fact, it doesn't cause a pattern interruption. It doesn't stop him. You want to make sure that if you create a question in the mind of your reader, you did not do so by accident. It's okay to create a question in the right mind of your reader, but you have to know you're doing it. Anybody here who's ever been to a seminar where someone's up there presenting a lot of information, oftentimes they'll say something and something in your mind to say, huh? What was, wait a minute, what did he mean by that? That's a massive pattern interruption. You have completely dropped out of flow. The presenter has totally lost you, and he's not going to get you back until you get that question answered. I read the Lord of the Rings trilogy. In the first book, Brotherhood of the Rings, Frodo gets stabbed by a ring wraith, and they bring in this elf to take Frodo to Rivendell. Tolkien spends 50 pages giving us the whole life history of this elf. I read all 3 volumes, and when I finished The Return of the King, I thought, where is the elf? He never came back. I was furious. He ruined the whole series for me because he put that guy in there and created an expectation that he was going to be a major character, and they never brought him back. I spent the whole time looking for this elf to come back, and it ruined the whole thing for me. I was annoyed. So be careful of how you create expectations in the mind of your reader. Tell them what you're going to tell them, and then tell them that in the order you told them you were going to tell it to them. This keeps them in flow. When they read the facts, they need to read one fact and know and understand intuitively when they read the next fact how these two fit together. If it's not clear, you may have to go to break. We'll be right back. This is Randy Kelton, Rule of Law Radio. I actually didn't fall off the cliff this time. We'll be right back. Okay, we are back. Randy Kelton, Rule of Law Radio. Statement of facts. When you put in facts, sometimes you may have to put in facts that are not material. For the most part, you want all of your facts to be material. You want them to matter. And you want them to have foundation. So sometimes in a statement of facts, since you're not giving explanation, you may have to add some facts that are not necessarily material, but have the purpose of giving foundation or direction. So you maintain a line of referential index so that when the reader reads one fact, material fact, and the next material fact, he already understands why that fact matters. And sometimes you have to put in a couple that are not material to the case overall, but are necessary to direct the mind of your reader so he doesn't stop and wonder why you have that fact in there. Once you've done this once, it'll become very clear what we're doing here. So you develop your set of facts to mirror the order, mirror what you're going to ask for in the order. You develop facts that a reasonable person of ordinary prudence could read, and they would interpret your facts to go to the conclusions you're going to ask the reader to come to in the order they're going to expect to find them. And if you've already told them what you're going to be proving, they will read these facts from the perspective of your original introduction that lists all of the things you're going to prove. They'll look at the facts and see how they apply to all of these things you're going to prove, and this will help you maintain flow. And once you have your statement of facts, then you go to your argument in support. Now, the argument in support should obviously follow the statement of facts. What I normally do when I create a argument in support, or points in authorities, whatever they want to call it, I like to call it a statement of factual accusation, because I'm going to take the facts, I'm going to copy them down into this section, and then I'm going to start filling in the arguments that we've been careful to keep out of this thing. Now we start filling in the arguments as to why these facts matter. Your only purpose in the trial court is to get the facts and the law on the record. You don't never expect to win in the trial court. Now, you may win in the trial court, and if you do, that's great, that's wonderful. But where you really expect to win is on appeal. So all you're really doing in the trial court is getting the facts and the law on the record. The statement of facts is where you get the facts on the record. You have to get the facts on the record with foundation. In order for a fact to be accepted into the record, it must have foundation, and that's what our story does, is it tries to develop foundation for each of the facts. And then now we go to the argument in support. And the argument in support, a few rules. Never, ever make a proactive statement of law out of your own mouth. You can make all the proactive statements of law out of your own mouth that you want to, and the judge will listen patiently and may even nod agreement. He may actually agree with you. You can make a convincing and cogent argument, and the judge will sympathize with you and agree with you, but he cannot rule in your favor. The judge cannot rule the way he thinks he should rule. He cannot rule based on what he thinks is just. And elsewhere in this document, I speak to the fact that the courts are not there to provide justice. The courts are there to provide a consistent application of law. If you want justice, if the consistent application of law is not generating justice, go to the legislature and insist that they change the law. The last thing we want is a judge getting up there on the bench and deciding what he personally thinks is just at this particular moment. Because he may just have had an argument with his wife. And if you're in a divorce proceeding and you're the wife, you don't want that judge deciding what he thinks is just at this moment. You want him applying the law to the facts. That's all. Leave justice to the legislature. So we want to give the judge the facts and the law. We've already gave him the facts. Now we go in and apply the law to the facts and show how these facts should lead to a particular conclusion. And we'll get to the conclusion in a moment. Citations. Anytime you put a citation in the body of your document, you should always mark it. I'm not familiar with how to do it in WordPerfect, but in Microsoft Word, you can mark citations as a special section for that purpose. And it's under the very top ribbon, you go to References, and then about 2/3 of the way across. So the first thing you've got is Table of Contents under References, and we'll talk about Table of Contents in the Style section. For legal documents, that is of critical importance. And then about halfway over, you have or all the way at the left-hand side, you have Table of Authorities. So when you have when you put a citation in, highlight the citation, then go to References, mark citation. And then it'll pop up a screen where you can select whether it's case law, statute, treatise, whatever. And you mark that. And Just click on it and keep going. It puts in a set of code that you normally can't see. There's a way to turn it on and off, but normally it doesn't appear in the document. So you won't really see it. It won't interrupt the document. But when you're finished, you can set your cursor somewhere on the page where you want your table of authorities to occur, and you click references, mark citation, and then there's a box up there for table of authorities. You click on it, and it will automatically create your table of authorities for you. This will save you a tremendous amount of work, especially if you're doing a habeas, mandamus, or certiorari, or an appeal. Appellate documents require that they have a table of authorities and a table of contents. So when you're most of all of this, all the citation markings should occur in your argument in support. You'll have a little bit of case law in your jurisdiction and venue, but for the most part, all of your case law should occur in your argument in support. Okay. Once you've finished the argument in support, then you write your conclusion. Essentially, you say, we just went through all of the facts and the law. Now, this is what you should conclude. And in this conclusion, you should address each cause of action and each element. In the argument in support, there's a section I don't see in here that I should have in here, and that is causes of action. You should list out your causes of action. Generally, I do that in the argument in support. As I argue these, I state a cause of action, and then I state the facts that apply to that cause of action, and then apply the law to the facts. So you will incorporate your argument in support with causes of action. Or you can call it, a lot of documents have this labeled causes of action. So you don't want to just list causes of action. A lot of pro ses, they claim a cause of action and they just list the cause of action, list all the elements, and they don't give the facts and the law to support them. So, okay, argument in support done. Then we do a conclusion. We briefly show how the facts and the law are such that the judge should conclude that this element exists, this element exists, this element exists, and therefore you have a right to this outcome. Okay. Once you have the conclusion finished, and the conclusion should follow the prayer or the order, same order of issues as you find in the order you want the judge to produce. Now you create your introduction. You notice you create your introduction next to the last. The last thing you're going to create is the heading of the document. But the next to the last thing you create is your introduction. Now that you've put all of the facts, causes of actions, argument and support, now you go up to the top and tell the court or tell the reader, this is what we're going to prove. And you give a brief statement of everything that you already have in the document. This way, when a reader reads the introduction, and from the introduction goes to the statement of facts, the statement of facts will precisely follow the introduction. The argument in support will precisely follow the statement of facts. The conclusion, the prayer, they will all follow one from another. And your reader will be able to read this and never lose track of where he's at. It will protect you from wandering around in your arguments, from re-arguing things 2 or 3 times, and just generally getting lost in the documents. Real short documents are not a problem, but large, complex documents, original pleadings, can be very difficult to keep your line of thought, and this method will help you do that. When we come back, I have one more section that's on document styling. And that's all. I'm going to run out of time, so I won't do any more on this tonight. This is Randy Kelton, Real Law Radio. Our call-in number, 512-646-1984. We have the call lines open. We'll start taking your calls after this section.
It's all according to the will of the Almighty. I read his book and it says he cares not for the unsightly. These warmongers come by that term rightly. I won't pay for the war with my body. Ain't gonna pay for their car with my money.
Okay, we are back. Randy Kelton, Rule of Law Radio, and we're talking about how to write legal documents. That's the basic structure of a legal document. I'm running out of time when I'm getting to the good part. I'll go over some of this. I'll probably use this segment, and then I'll finish up. Document styling. One of the things I suggest is you put a heading on every single paragraph and use the styles heading from your word processor. I'm sure that WordPerfect has it. WordPerfect is the reason I'm mentioning it is it was designed primarily for lawyers. So it's very lawyer friendly. And a lot of lawyers still use WordPerfect. But Microsoft Word has kind of dominated the industry. So and I use Microsoft Word, so I'm going to speak to how this is done in Microsoft Word. When you create headings, on the very top ribbon, if you click Home, then over toward the left-hand side, you'll see a section labeled Styles. The Styles section will contain all of your headings. Sometimes if you pull a document down off the internet or you send a document from someone else, the Styles section can be full of trash. Primarily, I try to open the blank document and then go into the blank document. And all of the headings that I don't know what they are, just delete them. Because if you need a heading, the headings we need for what we're doing here are their default headings in Microsoft Word for them, so you don't have to worry about deleting them. Every time you change formatting on something, one of the weaknesses of Microsoft Word is they add a style heading for that, and you can wind up with 100 style headings. It's a real pain in the neck. So I take them all out. Mainly what you need are the headings, labeled headings. So I won't go too deep into how to use the style headings. You can get some tutorials on the web on how to do that. But if you click in the front of a sentence, if you put a sentence in as a heading, then you can click on the styles box. It shows some that you can see, but you can't see all of them. So if you go down to the right-hand side, the bottom of the box is a little down arrow, click it, and it opens a box that shows all of your style headings. I generally style them with heading 1, 2, 3, 4, 5, and there's a way of changing the style of those headings. We won't go to that tonight, but you want a heading on each paragraph, main headings, subheadings, subheadings. This does two things. One, it creates a navigation pane. If you go to View on the top ribbon, and the second section over is labeled Show, and in that there's Ruler, Guidelines, Navigation Pane. You bring up your navigation pane, and the navigation pane will give you a listing of all of the headings, and it looks just like a table of contents. And each item in that table of contents is hyperlinked. So if you have a really long document, and you have used headings throughout, then you can open this navigation pane, go down it, click on it, and just jump to any place in the document you want to. But that's not the primary reason I suggest we use it here. When we're writing legal documents, you want to make sure you keep your arguments in order, and you only want to make an argument one time. I was recently going over a very large document for someone. First thing I did is went down the documents, looked at a paragraph, and gave it a heading. I put a heading on every paragraph in the whole document. It was time-consuming. It was tedious. But it was a 50-page document. So human beings can't read 50 pages and make sense of it unless it is extremely well-structured and documented. Headings give you documentation. It tells you this is precisely where you're at in the document. Yes, it uses up more space and it makes the document bigger, but it also makes it so that human beings can read it and make sense of it. So you put the headings on every paragraph, and then when you bring up that navigation pane, like in this document, I found two places in two different sections where I had the exact same heading on a paragraph. And that was a big-time red flag. So now I can go back and look at these, and sure enough, you argue the same issue two different times from slightly different perspectives. And for a reader trying to understand the document, this will be very confusing. So using headings helps you keep your document well-ordered. Keep each section flowing from the one before. Okay. Now we have the document headings. Now we're going to spend a little time on some of the more fun stuff. Some of the more sophisticated tools that we can use. Once you get this structure down, that the structure that I've went through up to this point will make it much easier for you to develop a very large document because you're developing it in smaller pieces. Not only will it give your reader referential index, it will give you referential index. You will always know where you're at in the context of the argument. Now, once we got that part out of the way, we don't have to spend all of our time worrying about, did I argue this already? Is this in the right place? You got that part taken care of. Now we can go down to the fun stuff. Pacing, leading, reality stacking, analog marking. There's all these cool things we can do. There are a very large number of very powerful tools we can use to increase the effectiveness of our documentation. One of the most effective, but maybe the most tedious and difficult to produce is meter. If you have, like, one of the places you might use meter is in your introduction. If you take your introduction, write the introduction, then go through the introduction and count the syllable sounds in each sentence. Meter has 2 syllable sounds. Alliteration, 5 syllable sounds. Count all the syllable sounds and then look how many syllable sounds are in each sentence. Then get yourself an average. If it's very short, you can set all the syllable sounds so that they are the same for each sentence. I have one here where I've actually done that. I can get it to pop up. There it is. Okay. Meter in prose is so subtle, it will hide behind the content. In rhyme, meter jumps out at you, but in prose, it will seduce you. The mind always looks for patterns. When you set your prose to meter, your mind will recognize the beat, and rapport is a certainty. Each one of those stanzas has 8 syllable sounds. And as the reader reads this, consciously they won't pay any attention to that. But the inner mind will say, ta-da, 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 ta-da. It will expect you to land on that beat either with a period or a comma internally. And if you do that, it deepens rapport because it creates a subtle expectation. And when you meet that subtle expectation, the reader has the experience of rapport with the writer. It's really subtle. I have some others here where I have set one. I wrote the paragraph. I counted all the syllables. Averaged. I got a high average and a low average. I had a high average of 15, a low average of 11. So I went back and reworded the paragraph so that the first sentence had 15 syllable sounds, the second syllable had 11 syllable sounds, 15, 11, 15, 11. There is no way the conscious mind will ever pick that up, but the inner mind will. The inner mind, the part that pays attention to structure and referential index, it'll pick that part up. If you have a part you want your reader to go through and you don't want the reader interrupted, you want to make sure they go through the whole thing without an internal interruption, set it to meter. There are other tools that you can use while doing this. Pacing and leading is one of them. In order to establish rapport, I'll make statements that you can identify with. I will speak to things in a way that you've heard them before. Sometimes when I'm talking to someone that I can actually see, it's different here on the radio because I can't get direct feedback. But if I'm trying to pace, like one of the things I do is conversational induction, I'll describe what you looked like 20 years ago. You don't look like that now, but it's what you looked like 20 years ago. And as I state these individual characteristics, if I've got the person in rapport, they'll tend to nod, yeah, I mentioned this characteristic, and they go up inside, and yeah, they recognize this, and yes, they recognize this. They recognize how to fit together. I produce a subliminal pace. This may sound a little odd and arcane, but it's really pretty easy to do. We all do it all the time. When we talk to people, we try to talk to them in a way that they can make associations to what we're talking about. So you pace, do at least 3 paces, and then from the pace you lead. You tell them about this kind of legal issue, and you tell facts that they will absolutely accept, and then you lead to a fact that they may not necessarily accept quite so easily, but since you've paced them, they will tend to attach this fact to the others without interruption, without question. Which goes to the next thing. I'm not going to have time to get into pattern interruption and alliteration. I would like to, but I'll save all of this for maybe next week. I'll go into some of these subtle tools we can use when crafting a document to get a better outcome. We're not talking about misleading someone or confusing someone, but helping people to better understand what they're reading without accidentally tripping them up. Okay. When we come back, we're going to start taking calls. This is Randy Kelton, Wheelbarrow Radio. Our call-in number 512-646-1984.
Now.
This is the Logos Radio Network.
Ain't gonna blind me. Don't bore me.
Okay, we are back. Randy Kelton, Wheelbarrow Radio. And we're going to start going to callers. What I just presented, that's the first time I formally presented that as a single subject. So I was a little shaky in some places. I will do this again in a couple of months so that I can get this presentation down so that it flows better than it did today. Okay, now we're going to go to callers. We're going to go to a first-time caller, to Barbara in 34 area code. What state's that?
Oklahoma.
Barbara, Oklahoma? Oh, okay. Okay. What do you have for us, Barbara?
Okay. I've been divorced for 2 years, and I share custody with young children. I'm the primary, and he gets them every other weekend. Every time he gets upset with me, he files a case with the Department of Children and Families that there's either hazard in the home or there's child abuse and such. The case is always dropped, but I'm on case 5 right now, and they come into my home. They tell me that they have to take pictures of my home. They go and take pictures of my children. They go to the schools. And
okay, hold on. Are you in divorce proceedings, or do you have a final decree?
A final decree from 2014.
Okay. How many of these complaints has he filed?
5.
And all of them have been ruled to be unsupported?
I'm sorry, I didn't hear what you said. Sorry.
Were all of them determined to be unsupported?
Yes, all of them were dropped and determined to not have any evidence that
okay.
Anything.
Do you still have a lawyer?
No, I don't.
Okay. You might consider petitioning the court for a restraining order.
I tried that, and because I had the divorce, he was very, very violent, and I told him, I even had an injunction, a temporary injunction, told him that he pushed me, and the judge actually told me word for word, if I got out of the way, I wouldn't have been pushed. That should have got a judicial misconduct complaint against the judge. That's that's a procedural due process violation. I would definitely, understand the judge is not your buddy. Right.
He doesn't have to be your friend. The judge has 2 primary duties. He must determine the facts in accordance with the rules of evidence, apply the laws that comes to him to the facts in the case. When you go to the judge and ask him to do something, you must give him facts and law. If you just go to the judge and say, this bad thing happened, and I want you to do something about it, technically he has no power to rule in your favor. Now, he's not going to tell you that because he can't give you legal advice.
Okay.
So when you go to the judge, and you can make a very convincing argument as to why he should do something to help you, but if you don't give him facts and law, you haven't given him anything he can work with. But for a judge to say that when you were subjected to essentially, that's a simple assault.
And I had a lawyer at the time when I...
Hold on. What were the circumstances of the push? Were you blocking his egress?
No, he wanted to get into my room, and we had been separated for a while, and he wanted to get into my room, so he was trying to push me through my room.
Did you charge him with unlawful entry?
No, because he had just taken his things out at the time. The lease is in my name, and they told me I had to put him in to get his things out. He had
that changes everything.
Okay.
He was attempting to enter the premises under apparently a court order.
No, it wasn't. The sheriff was just allowing him to come in and get his things, and all his things were put out, so there was no...
Okay, you can't. Okay, the judge was right. He had a right to enter. You had no right to block his entry. Now, if he just pushed you because he was angry or something, that would be different. But if you were blocking entry to a place that he had a right to enter, then the judge was right.
Well, he had already gotten his things, so now he was just coming in to argue with me and argue.
Okay. There's a way to do this.
Okay.
If he comes in and he doesn't get his things, but he argues with you instead, call the police.
Yes, I did that.
Make a report against him. There are other things you can do. For instance, if someone pushes me, they get a criminal complaint for assault. Now, for the most part, the police don't like to take complaints, especially in family law situations, because people in family law situations are generally, they're in a situation where they've totally failed to control a situation. And the situation's gotten out of hand. And now they want someone else to come in and control a situation that they could not control. I've known a number of police officers, and when I ask them, what are the calls that you fear the most, they always say family calls.
Wow.
Always. It terrifies police. They can't ever do anything right. No matter what they do, somebody's going to be PO'd at them. Mm-hmm. And they never know what's going to happen in a family call. It's so incredibly unpredictable because people are so on edge emotionally that we often don't make really carefully calculated decisions. If you are to take control of your situation, you have to set your anger aside. And I know that is extremely difficult to do. Have you listened to this show before?
No, I was told about it today. My brother is an avid listener of the show.
Okay, what we do here is we try to give people tools they can use. And the tools that we offer are not always straightforward.
Right.
We show you how to be somewhat more conniving. Mm-hmm. One of the things that we never do is give fair warning.
Okay.
I would suggest when you're dealing with your husband, never give him legal advice. Don't tell him what he should do, what he shouldn't do, and don't give him fair warning.
Okay.
If you want to get control of the situation, you need to back up and go at it from a more controlled perspective.
Okay.
I don't do a lot in family law, but I show people how to go after public officials. Now, going after your husband is a lot easier than going after a public official.
Yeah.
And if you want to, when I say going after your husband,
right,
I really will present a set of tools that you can use to take control of your responses to what he does.
Right.
We get in these situations to where we get conditioned.
Mm-hmm.
In failing marital situations, we condition one another to react badly. He says something and it pushes one of your buttons. And when he pushes your button, it triggers a certain response from you that pushes one of his buttons. And you go back and forth. You think back on your interactions with your husband and take out the content and look at the structure. How many times have you gone through the same routines, the same arguments back and forth over and over? And they always lead to the same place. When we come back, I'll talk about something that wasn't what you asked for directly, but it may give you a tool to interrupt these spiraling patterns, and a lot of this may fix itself. Randy Kelton, Rule of Law Radio. Our call-in number, 512-646-1984. We'll be right back.
Don't touch that dial. Seriously, it may be rigged to scan your hand. I'm Dr. Catherine Albrecht, back to tell you how a children's media corporation is developing some scary sci-fi next.
Privacy is under attack. When you give up data about yourself, you'll never get it back again. And once your privacy is gone, you'll find your freedoms will start to vanish too. So protect your rights, say no to surveillance, and keep your information to yourself. Privacy, it's worth hanging on to. This message is brought to you by StartPage.com, the private search engine alternative to Google, Yahoo, and Bing. Start over with StartPage.
Bet you didn't know Disney had a research arm. Well, they do, and what they're developing is not child's play. How about doorknobs that recognize your touch, or phones that go silent when you wave your hand, or chairs that dim the lights when you lean back? Those are just some of the smart objects being built by Disney Research, where things around you will be aware, ever watching and anticipating your desires in an interactive, brave new world. But do we really want our furniture watching us? Once this stuff is linked to the internet, pretty soon the walls and even the doors will talk. Hey, let's lock the door on that idea. Throw away the key. I'm Dr. Catherine Albrecht for StartPage.com, the world's most private search engine.
Actually be kidding about chemtrails.
Looking for some truth? You found it. LogosRadioNetwork.com.
Okay, we are back. Randy Kelton, Rule of Law Radio, and we're talking to Barbara in Oklahoma. And before I move ahead, Barbara, as concerns your relationship with your ex, what would you like if you could design an outcome, design a relationship that you could sustain? What would you like that relationship to be?
Well, I'd like it to be civil without any blaming or any malicious behavior. Because when he gets angry at something, he just does these things. And I'm usually like the victim that usually just takes it and try to just ride over it. And I don't want to take that anymore because he's trying to damage my name.
Okay, that was the perfect answer. Now, how good are you at being devious?
I'm not very good at it at all. That's why I'm calling.
Okay, we're going to work on that. And I don't mean devious in a malicious way. Right. Devious in a way that will dramatically affect his behavior. Okay, you have to understand that we get into patterns, especially when we've lived with someone a long time. We learn how to deal with one another. I've been married to the same woman for 45 years.
Wow.
And I have learned how to handle that woman. Oh, yeah. She starts that do this, do that stuff. Well, what you do is you huff up and you tell her, yes, dear. We learn how each other reacts and responds. Well, it took us a long time. We separated for 5 years before we could come back and find a new normal. And what I'm about to deliver is something that helped us find that new normal. Once you interact with someone over a period of time, you develop patterns of interactions. He can say something or do something, and your response just comes out. He comes in, he pushes one of your buttons, and you do this little dance for him. Mm-hmm. You say this, he says that, you say this. You can choreograph where these interactions are going to go to. They always spiral down this same routine. And oftentimes you can see it coming, you can feel it when it's happening, and once it's over, you're frustrated at yourself for letting this happen again, but you don't know how to fix it. Well, I'm going to talk to you about how to fix it. Have you ever had someone say something or do something, and your reaction is not pause and reflect. Stop, objectively analyze, decide what to do, and then initiate a response. But instead of that, humans can do that. As far as I know, we're the only creatures on the planet who can do that. But for the most part, we don't. For the most part, we do whatever we feel like doing. And by feel like doing, I mean it literally and physically comes from your center, from your stomach. You feel your stomach tense, and that response just squeezes out. You don't stop. You don't stop and think, well, how should I handle this? Bam! It just comes out. I'm going to suggest to you that any time you have a response that's not pause and reflect, but just comes out, well, that's not yours. That's his. Do you really think that he did not know exactly what kind of response he was triggering from you? Of course he knew. Okay, maybe he didn't know on a conscious volitional level, but at some level he knew. When I was 5 years old, I knew what would make you smile, frown, happy, sad. I pretty well knew the full range of human response within my native culture. To think that I could say something or do something and it trigger a specific response from you and me not know, well, that's naive. Of course I know. To think that he could come in and reach in and push one of your buttons and your insides just squeeze tight and this response just jumps out. Well, you might feel like you're reading him the right act, just letting him know how to cow ate the cabbage. Well, that is naive. Consider hubby. Hubby's has a horrible day at the office. Boss been on his case all day. Drives home in heavy traffic. He's miserable. Mama's had a great day. She fixed this great meal. She meets him at the door, gives him a big hug. He just grunts and pushes past her, drops down in the chair, plops some potatoes on his plate and says, "Pass the darn gravy." Well, in this country, in this culture, what's Mom going to feel like doing with that gravy? This don't take a rocket scientist. And what if she bounces the gravy boat off his head? He's going to say this. She's going to say that. He's going to say this. She's going to wind up in a room crying. He's going to wind up in the den sulking. Okay, Mom's had a great day today. And she realizes, okay, Papa's in a bad mood. I got that part. And I don't want to go through all this routine. So she don't throw the gravy boat at him. What does she do instead? Oh, dear, have you had a hard day? Not. Okay, here's the deal. We know how to elicit responses from other people. If someone attempts to elicit a positive response from me, I'm going to give them exactly what they expect. And this is how we generate a well-ordered civil society. We learn how to react and respond to people. But sometimes we generate responses that lead to negative outcomes, and they're automatic. They run outside of conscious awareness. Consciously, we pay attention to the external details. But we got this other part. For want of a better term, I call it an internal librarian. It keeps all of these things we've learned how to do, and it stores them in a contextual framework. And I call them mental drawers. You're moving along in a normal state of awareness, and somebody comes along and stomps on your toe. Well, how do you respond to that? Well, the inner mind looks at the circumstances. If the guy had a handful of boxes and he's staggering around and he takes a step to the side and smashes your sore ingrown toenail, how do you respond? Do you get angry at him, or do you understand that he couldn't see what he's doing, he didn't do it on purpose? Whatever the context is, your inner mind will determine what the appropriate context is. And then it goes inside and it opens this mental drawer. And in that mental drawer, you've got all the things you learned how to do in this particular context. Mm-hmm. To the degree that you are consciously aware of the limitations of the internal mental context somebody else has just triggered, you don't know what you're doing. If your husband says something and it triggers angry, and you're not consciously aware of the limitations of the responses in your angry drawer, you're out of your conscious mind. You don't know what you're doing. Mm-hmm. If your parents were empathetic and understanding when they were angry, you may have that in there. But if they weren't, and you don't have it in there, and you're not aware of those limitations, you're out of your mind. You're acting outside of your conscious awareness, and you're being manipulated. He knows exactly how you're going to respond to him. Been there, done that. So the trick, and what we'll address when we come back on the other side, is how to take the things that people do automatically, do essentially outside of conscious awareness, because similar stresses and pressures on him are eliciting his interactions with you. And those interactions wind up eliciting negative responses. Your negative responses gets one back. And you go around in this mental circle. And it's, for the most part, out of conscious awareness. And when we come back, I'm going to show you this really cool tool with which you can trip him out of his automatic pattern and force him to find another way of behaving. Randy Kelton, Root of Law Radio, our call-in number, 512-646-1984. We'll be taking your calls all night. So give us a call. It generally picks up toward the end. So if you have a question or comment, call in early. We'll be right back.
Easy.
Well, you know, karma's lurking around the corner. You better watch every step you take. And good will follow you. Yeah, brother Jerry, sing reality. Okay, karma's lurking around the corner. Sing, Jerry, come.
Okay, we are back. Randy Kelton, Root of Law Radio, and we're talking to Barbara in Oklahoma. Okay, you're going to like this, Barbara. It is so subtle that he will never catch it. So, okay, somebody says something or does something, and your response just comes out. It's automatic. If you respond to that, you're kind of like a little spider hanging on a piece of web. And somebody gives a little tug on it, and you do this little dance for him. Okay, you might feel like you're reading him the right act and letting him know how to eat the cabbage. You can throw the gravy boat at him, but you'll go through the same routine you've been through 100 times. So the trick is, whenever somebody says something or does something, and your response is not pause and reflect, it just comes out, it's not yours, it's theirs. And the rule is, whatever you feel like doing, don't do it. Okay. And immediately, when you interrupt yourself and don't do what you feel like doing, you don't bounce the gravy boat off his head. Immediately, something else will come to mind. And the trick and the power of the procedure is don't do that either. I call this my rubber ball theory. I could give you 3 rubber balls, one hard, one soft, one medium. Based on your experience in your environment, you could pretty well predict how hard to throw each one up against the wall so it'd come back where you could catch it. Within a given range, maybe a little higher, a little low, off to one side or another, but within a given range, I could pretty well predict your behavior. I could do that when I was 5. So you know your husband can. So the trick is, don't do what you feel like doing, and immediately something else will come to mind. In Mama's case, she realizes she had a hard day, and instead of throwing the gravy boat at him, she says, "Oh, dear, have you had a hard day today?" And what happens? He unloads on her. He gets to unload all his misery and grief. So if she throws a gravy boat at him, he gets to unload on her. If she reacts nurturing, he gets to unload on her. So don't do what you feel like doing. Don't do the second thing. Wait for a third thing. And here's the rule for the third thing. The only real rule is, whatever you do, make sure it's something that he won't anticipate. The more subtle, the better. I got this little invisible hook. Now, it's just a little one, because if I catch you running around in one of these mental circles where you keep trying to trigger the same negative response over and over, and I reach out and I trip you and I knock you flat on your face, you might not know what I did, but you're going to know I pulled something on you, and it's going to trigger all your defenses. So it's just a little one. In this case, Mama says, she pretends like he asked her real nice, will you please pass some of that delicious gravy? And she responds to that instead and says, "Oh, sure, here you go, dear." Now he's sitting over there. He knows something's wrong with that. He's just not sure exactly what it is. And psychologically, that's called pattern interruption. And there is nothing more psychologically disruptive than a pattern interruption. Than one of your expectations coming false. We've all had the experience where something happened and we're just stopped. We don't have any idea what to do. For a human being, that equates to not being able to secure yourself in your environment. that triggers all of your emergency warning signals to go off. But if you do it on something really, really subtle, like in this case, she just responds as if you ask her nice, it causes a really subtle pattern interruption. You don't want him to catch you at it. You don't want him to realize you did that on purpose. Because if he realizes you did that on purpose, it won't be effective. And that prevents something else. You can never try to manipulate someone with this technique. If you respond to someone in order to interrupt a negative pattern, and you respond in a way that tries to manipulate them to respond a certain way to you, they will catch you every time. So all you do is trip him and then step back and wait. If one of my expectations comes false, this automatic pattern I've been running for years is pushed up into my conscious awareness. And my inner mind says, I've been running this a long time and it generally works, but this time it didn't work for squat. So you need to look at it and fix it. So it takes something that goes on out of awareness and pushes it up into the consciousness. So he has to look at it. Well, if he don't know you really did anything to him, then he gets to look at this clean and say, what went wrong here? How can I do this in a way that comes out to where I can anticipate the response? That is the most important thing. We have to be able to anticipate a response. It's kind of like you take these 3 rubber balls. You take the medium one, feel its weight, feel its density, and you throw it up against the wall. Well, you could expect that it'll bounce back high or low off to one side or another. So hubby's thrown his mental ball up against your wall. You don't want to bat it back high or low off to one side or the other. What you want to do is make it splash and slide to the floor. Pattern interruption. Now he's stopped. He's stuck. So what's he going to do? He's going to go over and pick it up. Feel its weight. Feel its density. Feel the wall. It's flat, hard, and smooth. Everything in his environment says, that thing should have come back to me. So what's he going to do now? He's going to back up. He's going to throw the ball again. But he's going to throw it harder. What the heck did you do to this darn gravy? If you interrupt someone that's been running one of these patterns on you for years, and you've interrupted them cleanly, you can expect them to come back at you much stronger. When I first worked out this procedure, Mama would get me every time. When I first began to interrupt her, she'd come back at me like gangbusters. Mm-hmm. It took a while. I had to do it a few times. Once I understood it, she would push that button and I'd do this dance, and in the middle of it, I would realize what I just did. I fell for it again. And then she'd nail me again and I'd fall for it again. And one time she pressed that button and I gotcha. I caught it before I responded to it. I guarantee you, Barbara, the first time you catch him trying to push one of your buttons and you catch yourself before you respond, that day will change everything. That's when you realize you can take control of situations that you've never felt like you had control in again before. And all you do is interrupt him. Don't try to manipulate him. Don't try to get him to respond a certain way. Just interrupt him so that he has no idea what you did. Now you can tell when you got him, because you'll see his eyes go out of focus. He'll just freeze there for a second. And generally it takes about 2 or 3 seconds from a good pattern interruption for somebody to get their struts back under them, figure out something to do. Then he's likely to come back harder. Once you can interrupt that one. I have never had to interrupt someone more than twice. People will change behaviors that they've done all their lives. Sometimes change them so dramatically they'll get amnesia for ever doing them. It can be so effective it'll scare you. But it really does work. I present this as a tool for affecting positive change in other people. And it's positive change because you can't manipulate a particular change. Never, ever does that work. It will catch you every time. We got great tools for telling when somebody's trying to manipulate us. But when somebody just slides a little speed bump out there and we stumble over it and we look around, what happened, we don't have a clue, that is incredibly profound, an incredibly profound experience for human beings. They will pull up these patterns, make adjustments to them. They will change behaviors they've done all your life. You will be amazed. This will give you a tool to begin to interrupt these negative patterns, and then you can go back to treating one another like with dignity and respect. And so if he comes up with a different behavior and it's equally unsatisfactory, you just keep interrupting him until he gives you a good behavior, and then you respond positively. Now, I present this as a way of affecting positive change in other people, but that's not really true. This tool, once you get it, once you feel it, it will allow you to begin to recraft your own behavior. You'll actually get to consciously and deliberately reprogram your own behavior so that he won't be able to interrupt you. Other people won't be able to interrupt you. What we show about how to go after public officials, most everything I demonstrate goes to this. I go into court and I react and respond to the judge in a way that he has no idea what to do with me. And that interrupts a lot of this nonsense and BS, and we get down to real business. We're about to go to break. We'll pick this up on the other side. Randy Kelton, Rule of Law Radio. Our call-in number, 512-646-1984. This is our top of the hour break, so it would be a good time to go check out our sponsors. We have our fundraiser on, and it's doing incredibly poorly. We're struggling to keep this thing on the air, so check out our sponsors and help us keep this thing on the air. We'll be right back.